Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in United States versus Zubaydah, certiorari to United States Court of Appeals for the Ninth Circuit. Argued October 6, 2021. Decided March 3, 2022. In the aftermath of the September 11, 2001 terrorist attacks, the Central Intelligence Agency believed that Abu Zubaydah was a senior al-Qaeda lieutenant likely to possess knowledge of future attacks against the United States. Zubaydah, currently a detainee at Guantanamo Bay Naval Base, says that in 2002 and 2003, he was held at a CIA detention site in Poland, where he was subjected to enhanced interrogation techniques. In 2010, Zubaydah filed a criminal complaint in Poland seeking to hold accountable any Polish nationals involved in his alleged mistreatment at the CIA site, ostensibly located in that country. The United States denied multiple requests by Polish prosecutors for information related to Zubaydah's claim on the ground that providing such information would threaten national security. Zubaydah filed a discovery application pursuant to 28 U.S.C. Section 1782, which permits district courts to order production of testimony or documents for use in a proceeding in a foreign tribunal. Zubaydah asked for permission to serve two former CIA contractors with subpoenas requesting information regarding the alleged CIA detention facility in Poland and Zubaydah's treatment there. The government intervened and asserted the state secrets privilege in opposition to Zubaydah's discovery request. The district court rejected the government's claim that merely confirming that a detention site was operated in Poland would threaten national security. The district court, nevertheless, dismissed Zubaydah's discovery application. It concluded that the state secrets privilege applied to operational details concerning the CIA's cooperation with a foreign government, and that meaningful discovery could not proceed without disclosing privileged information. On appeal, the Ninth Circuit agreed with the district court that much of the information sought by Zubaydah was protected from disclosure by the state secrets privilege. But the panel majority concluded that the district court had erred when it dismissed the case. It believed that the state secrets privilege did not apply to publicly known information. The panel majority also concluded that because the CIA contractors were private parties and not government agents, they could not confirm or deny anything on the government's behalf. Given these holdings, the panel majority determined that discovery into three topics could continue: the existence of a CIA detention facility in Poland, the conditions of confinement and interrogation at that facility, and Zubaydah's treatment at that location. The Supreme Court, the decision below, judgment is reversed and the case is remanded, and a lot of people joined in a bunch of different combinations of this opinion. Justice Breyer delivered the opinion of the court with respect to all but parts 2B, 2, and 3, concluding that, in the context of Zubaydah's Section 1782 discovery application, the Court of Appeals erred in holding that the state secrets privilege did not apply to information that could confirm or deny the existence of a CIA detention site in Poland. The state secrets privilege permits the government to prevent disclosure of information when that disclosure would harm national security interests. See United States versus Reynolds. To assert the privilege, the government must submit to the court a formal claim of privilege lodged by the head of the department which has control over the matter. The court itself must determine whether the circumstances are appropriate for the claim of privilege. However, in making that determination, a court should exercise its traditional reluctance to intrude upon the authority of the executive in military and national security affairs. It's Department of the Navy versus Egan. If the government has offered a valid reason for invoking the privilege, the showing of necessity by the party seeking disclosure of the ostensibly privileged information will determine how far the court should probe in satisfying itself that the occasion for invoking the privilege is appropriate. That's quoting Reynolds. The narrow evidentiary dispute before this court asks how these principles apply to Zubaydah's specific discovery requests. B. In certain circumstances, the government may assert the state secret's privilege to bar the confirmation or denial of information that has entered the public domain through unofficial sources. Here, the information held by the Ninth Circuit to be non-privileged would necessarily tend to confirm or deny that the CIA maintained a detention facility in Poland. The government has shown that such information, even if already made public through unofficial sources, could significantly harm national security. The CIA director stated in his declaration that clandestine relationships with foreign intelligence services are critical and based on mutual trust that the classified existence and nature of the relationship will not be disclosed. Given the nature of Zubaydah's specific discovery requests, there is a reasonable danger that in this case, a former CIA insider's confirmation of confidential cooperation between the CIA and a foreign intelligence service could badly damage the CIA's clandestine relationships with foreign authorities. The CIA contractors' confirmation or denial of the information Zubaydah seeks would be tantamount to disclosure by the CIA itself. The contractors worked directly for the CIA and had a central role in the events in question. The CIA director describes the harm that would result from the contractors responding to the subpoenas, not the risks of a response from the CIA or any other CIA official or employee. Zubaydah's need for location information is not great, perhaps close to non-existent. At oral argument, he suggested that he did not seek confirmation of the detention site's Polish location so much as he sought information about what had happened there. Here, the state secrets privilege applies to the existence or non-existence of a CIA facility in Poland, and therefore precludes further discovery into all three categories of information. The Ninth Circuit concluded to be non-privileged. This case is remanded with instructions to dismiss Zubaydah's current application for discovery under Section 1782. Justice Breyer delivered the opinion of the court, except as to parts 2B2 and 3. Chief Justice Roberts joined that opinion in full. Justice Kavanaugh and Justice Barrett joined as to all but Part 2B2. Justice Kagan joined as to all but Parts 3 and 4, and the judgment of dismissal. And Justice Thomas and Justice Alito joined Part 4. Justice Thomas filed an opinion concurring in part and concluding in the judgment, in which Justice Alito joined. Justice Kavanaugh filed an opinion concurring in part, in which Justice Barrett joined. Justice Kagan filed an opinion concurring in part and dissenting in part. Justice Gorsuch filed a dissenting opinion, in which Justice Sotomayor joined. Thank you for listening. If you'd like to support the podcast, see the PayPal link in the show notes, find me on Patreon, or contact me at rhodesscholar80@gmail.com. That's ROADS and the number 80. Thank you.